People often enter into verbal agreements without considering the legal implications of doing so. Whether it's agreeing to sell a car, hire a contractor, rent a property, verbal agreements can be legally binding in the UK if they meet the essential elements of a contract. And so in the next 10 minutes, I'm going to teach you some very useful knowledge as you go through life, which is when a verbal agreement becomes legally binding, what the essential elements are for an agreement to be binding, practical steps for ensuring your verbal contract is enforceable and remains enforceable, and finally, how to prove your verbal contract if someone disputes it. Remember, even if this information may not be applicable to you now, it will always be useful knowledge for you going forward, because it's a very common situation for a verbal agreement to be made and then one person to deny its existence. My name is Cal Sandu and I'm here to be your travel-sized, qualified legal advisor, here to help you simplify and understand life's most common legal challenges. So let's get started on the video. Okay, so for a verbal contract to be legally binding, we're looking for three primary things: offer and acceptance, exchange of value, and intention. Don't worry, I'm going to break these down for you nice and simply now. First one, offer and acceptance. There must be an offer by one party and acceptance by another. An offer is a clear and unequivocal expression of willingness to enter into an agreement and on certain terms. Then there must be acceptance. The other party must accept your offer unconditionally. Now, this acceptance can be explicit through words or implied through actions. What I mean by that is, for example, if you verbally accept to buy a car for £5,000, that is express acceptance. However, if you don't verbally accept but then take the car and start driving it, this can be considered implied acceptance. Silence, however, cannot be construed as acceptance. So if you have both an offer and an acceptance, then you're on your way in a verbal contract. Number two, there must be an exchange of value between the parties. This can be an exchange of money, goods, or services, or a promise to do something, or a promise not to do something. Some consideration must be something of value, though it need not be adequate or equal in value to what is received in return. The key is that something of value is exchanged, even if it's just a promise to do something. So you have an offer and you have an acceptance, and then you have an exchange of value. Now you need an intention. Intention to create legal relations. So both parties must intend for that agreement to be legally binding. Social and domestic agreements, such as informally between friends, are usually presumed not to have this intention, while commercial agreements usually do. For example, what I mean by that is verbal agreements in conversations, business conversations with clients, for example, or potential clients. There is an expectation that parties will hold to their promises. This is a commercial agreement. However, in social and domestic agreements, for example, a casual promise to a friend over dinner, generally a presumption that parties don't really intend to create a legal relation there unless there's evidence to the contrary. The fourth and second to last requirement is certainty and completeness. So for a verbal contract to be binding, the terms of the agreement must be clear and certain. Both parties should understand the obligations and the consequences of failing to meet them. A verbal agreement should leave no room for significant ambiguity or vagueness. And if there are insufficient specifics, such as it doesn't say what the scope of work is, it doesn't say what the payment terms are, the timelines, then you may not have a binding contract. So the agreement must be clear on each other's obligations. So let's recap what we've got to make a verbal agreement. We've got an offer and acceptance. We've got consideration and exchange of value. We've got intention to create legal relations, and we've got certainty in our terms. Now, finally, all you need is capacity. Both parties must have the legal capacity to enter into a contract at the time the agreement was made. This means they must have been of sound mind when the agreement was made, and the agreement was not made with a minor, for example, and was not made under undue influence or duress, which includes being in a drunken state. Okay, so now you know the 5 key elements you need in a verbal agreement for it to be binding: offer and acceptance, consideration, intention to create legal relations, certainty, and finally, capacity of the parties. If you have those, then either party should be able to enforce the agreement. To help you understand this, I'm going to give you a couple of really quick examples of verbal agreements which can form legally enforceable contracts. The first really good example of this is simple contracts such as buying groceries, hiring a taxi. These are all simple contracts that can be made verbally. Another one is employment agreements. So verbal agreements that establish terms of employment between two people can form legal contracts. Then you have service agreements like hiring a contractor, a tradesperson, or a home repairman. These services can be based on verbal agreements, provided all the essential elements were met. Finally, sales of goods. Verbal agreements for the sales of goods can be legally binding contracts, particularly if the goods are delivered and payment is made. So with those examples out of the way, now we're going to look at what you need to do if someone is disputing your verbal agreement and how to prove its existence. So while verbal agreements can be legally binding, proving their existence and the terms can be challenging. So the following steps are crucial to ensure that you have all the evidence that you need. The first step is to gather the evidence of your agreement. Written evidence such as emails, text messages, or notes, or anything that can support the existence of a verbal agreement. Finally, gather witnesses. Witness testimony can also be extremely useful if someone else was present during making of the verbal agreement, so do call upon those persons should you need them. Number 2 is performance of the contract. Now, performance of the contract can act as evidence of its existence. So if both parties have acted in accordance with the terms of the verbal agreement, this performance can serve as evidence of the contract. So gather any evidence that shows that both parties have performed as requested. Finally, payment or delivery. Now, even if making a partial payment or delivering part of the goods, this can indicate the presence of a contract. So if you have evidence proving that one party has paid or delivered or part delivered, then this can serve in your favor. So to summarize, if you've been able to gather evidence of your agreement, gather evidence that it was performed, or gather evidence that it was paid, this should stand you in good stead evidence-wise to prove your contract. Now, there are, however, some exceptions of contracts that cannot be made verbally, and these must be made in writing. So if any of these apply to you, if they're not in writing, unfortunately, they cannot be enforced. For example, contracts for the sale of land or the lease of land, these must be in writing. Number 2, consumer credit agreements. Those also must be in writing. Number 3, guarantees. In other words, an agreement to be a guarantor for someone. A guarantee is a promise to answer for the debt or default of another person. This must be in writing. And finally, wills. Any agreement concerning the will and distribution of someone's estate after death, that cannot be made verbally and must be in the form of writing and be witnessed. Okay, so now we'll look at, if you've made a verbal agreement, the practical steps that you should take to ensure that it becomes and stays legally binding. Now, the first thing you should do to protect your agreement is seek written confirmation. So whenever possible, follow up a verbal agreement with written confirmation, confirming all the terms that you made in your verbal conversation. This could be in the form of a letter or an email, for example, or even just a simple written contract. So I suggest you ensure the following points are confirmed and recorded following your conversation. Write down the scope of works, including the tasks involved, deadlines, dates of starting and dates of finishing, the value to be agreed in exchange, what is the promised exchange, the date the agreement was made. Number 2, document the key terms. So keep a record of all the key terms of the agreement and keep them safe as well. The third step to protect your agreement is to regularly maintain communication. So maintain regular communication with the other party to ensure that both sides still have a mutual understanding of the agreement and its terms and their obligations. So reminding the other party regularly of their obligations does go a long way. And the final bit of advice is, in complex or high value transactions, definitely seek professional legal advice to draft a written contract that reflects the agreement accurately. It's not worth the risk when you're dealing with high value agreements to leave it to chance. Get a lawyer to draft it correctly. Okay, so now you know the steps you should take after you've entered into a verbal agreement to ensure that it remains binding. So get written confirmation, document and keep safe the key terms, regularly communicate with the other party so that they're always aware of its terms, and get legal assistance when it's a high value transaction. Before we finish, then 2 very quick warnings that you should be aware of. Number 1, disputes. Remember, without clear evidence, it can become a case of one party's word against another party's word, and disputes can rise, leading to potential court claims and associated costs. So gather and preserve your evidence. Get it right from the start so you don't end up losing money on court fees. And number 2, consider the reliability of the parties involved. The reliability and trustworthiness of the parties involved play a significant role in the success of a verbal agreement. It's important to consider the character and the track record of the other party that you've made the verbal agreement with. If they seem unreliable, don't risk a verbal agreement alone and get a written contract drafted as soon as possible. So that sums up the advice on this topic. Remember, verbal agreements can be legally binding in the UK if they meet the essential elements of a contract: offer and acceptance, consideration, exchange of value, intention to create legal relations, certainty in its terms, and mental capacity. Remember though, certain contracts such as those involving the sale of land, consumer credits, guarantor agreements and wills cannot be agreed verbally and must be in writing to become legally binding. Finally, seeking professional legal advice and ensuring that the agreements are well documented can help prevent disputes and protect the interests of all parties involved. That concludes this video. If you have learned or taken anything of value from this video, please do drop me a like or maybe even subscribe to my channel to ensure that you have qualified legal advice in your back pocket at all times. Remember, while my content can and should be taken as reliable legal advice in general, this content is not a substitute for specific legal advice as it relates to your particular situation, and so shouldn't be relied upon alone. That being said, see you in the next video.